I know everybody thinks that the Constitution is being trampled at all times and we have Constitution rage, but I want to give you an example of our Florida Constitution being completely eroded by a new law. And what I'm going to do is I'm going to first tell you what the Constitution says, okay? Article 1, Section 14 of Florida's Constitution has said forever and ever that unless charged with a capital offense, or an offense punishable by life, and the proof is evident and the presumption is great, everybody gets a bond on a crime in the state of Florida. In other words, Article 1, Section 14 of our Constitution says you don't get a bond if it's a capital offense or it's punishable by life, those two things, and the proof is evident and presumption great. We call that an Arthur hearing where you sort that out. By the way, proof evident, presumption great is higher than beyond a reasonable doubt. If you just come with proof beyond a reasonable doubt on a punishable by life or on a capital offense, you don't get to hold them with no bond. They get to bond out on that. They're presumed innocent. They get to bond out. You have to go beyond a reasonable doubt all the way up to proof evident, presumption great. It's the highest standard we have in our criminal court system, is to hold somebody without bond pursuant to Section 1, Article 14 of the Constitution. All right, I laid the foundation for this little constitutional rant here. Now let's go to the brand new law that I just had to deal with in court, which is why I'm videotaping this. The new law is 907.041. And 907.041 is very subtle in the way that it screws with the Constitution. Listen to this. It says that you can hold somebody without bond on a capital or life felony, like the Constitution says, or a felony of the first degree. Now we've got even more crimes. And guess what? You don't have to have proof evident, presumption great, the highest standard, higher than beyond a reasonable doubt. You know all you need under 907.041? Just the judge's determination that there's probable cause to believe the defendant committed the offense. Really, that's it. Probable cause to believe that somebody committed the offense, and you're going to get to hold somebody without bond? That's not what the Constitution says. This new statute, thank God in my case, the judge didn't buy it, didn't buy the law, and granted my client bond. It was a first degree felony, and you're going to be seeing more and more of this. I think it will be declared unconstitutional. This statute cannot survive. Somehow it passed. Not surprising that things pass, but it's got to be struck down rather quickly. I give this thing a year, and I think it's going to be struck down, my humble opinion.